Okay, welcome everybody. It's just gone 1 o'clock, so we will make a start. So as I said, thank you for joining us today for the third webinar in our Child Safe Standards and Regulation series. Today's webinar is on child protection reporting, which is probably most commonly understood as mandatory reporting, although today we are going to cover the full range of reporting for child protection that exists here in the ACT. To keep things running smoothly today, we have turned off your picture and your sound if you're a participant, but we do have the Q&A function running, so you're welcome to post a question at any time or a comment, either into the chat or the Q&A function. Both are okay. At the end of the session, we are going to do a Q&A time. We haven't had a huge amount of questions submitted in advance, so during this time, if you would like to post a question, you can into the chat, and if you would prefer to say it verbally, then you can put your hand up and we'll make sure that we get your microphone untoggled for you. Please note we are recording today's session, and it would be our intention to pop this recording up onto our websites for others to access at a later date. So if you have any issues with this, please do let us know. We can do our best to make sure that you are not represented through that recording. And if you would like a copy of today's presentation, the slides that we were about to go through, then you can contact our team, my team, at the end of the webinar. Don't stress, we are going to have contact details put up at the end. All right, very good. Now, just double checking, can everybody see my first slide? Because I cannot, but hopefully it's up there. We are going to make a start now. Going to try and make a start. There we go. All right, so to kick us off, I would like to do an acknowledgement. So I wish to acknowledge the traditional custodians of these lands, which for me is the Ngunnawal people and other people with connection to the ACT and surrounding region. I pay my respects to elders past and present. I also acknowledge the emerging leadership capacity of First Nations children and young people and the importance and culture in giving their lives strength and meaning. I also acknowledge the enduring connection to country of all Aboriginal and Torres Strait Islander people and the ongoing impacts of dispossession and colonisation, recognising that the rights to these lands here in ACT have never been ceded. I would also like to just recognise any Aboriginal and Torres Strait Islander people that we have joining us on the call today. Now, working in the child safety sector, I also like to do an acknowledgement of survivors. So I would like to acknowledge the survivors of childhood abuse, including the adults, children and young people who experienced harm in all its forms, generally by those who were entrusted to protect them. I recognise the courage of survivors of institutional sexual abuse who shared their experiences and the Royal Commission into institutional responses to child sexual abuse. Those adults who came forward about their childhood experiences did so in the hope that all children will be protected, believed and safe in the future. Okay, so quick introductions. My name is Gemma Rowe. I am a Senior Capability Development Officer working on the Child Safe Standards at the ACT Human Rights Commission. I work for the ACT Children and Young People Commissioner, who is Jodie Griffiths-Cook. With me co-hosting today is Belle Hughes, who might flip her camera on very quickly and give a wave. She is from ACT Children, Youth and Families, which is part of the Health and Community Services Directorate. Belle is going to be presenting about child protection reporting laws, including mandatory and voluntary reporting a little bit later. We will share these contact details at the end, so don't stress about writing it down right now. So today we are going to cover just a very high-level outline of the regulatory frameworks for child safe standards and child protection reporting. We'll do a brief overview of the child safe standards and the scheme, and then we will look at both mandatory and voluntary reporting of child abuse and significant harm. And then we will finish off with a look at how the child protection reporting and child safe standards can overlap, and what actions you can take as an organisation to ensure that you are meeting requirements for both legal obligations. So a bit of a timeline of child safety legislation. In the ACT, there are a number of legislative requirements that address child rights, safety and wellbeing. And these form what we sometimes refer to as the protective framework to prevent harm to children and other vulnerable people. So this includes the Human Rights Act, which was introduced in 2004, and the Children and Young People Act, which came in 2008, and that one actually superseded the previous Children's Services Act and the Children and Young People Act from 1999. Those two laws, I guess, codify some key requirements in relation to children's rights and promoting and protecting the safety and wellbeing of children and young people. So they introduce concepts like the idea of decision-making in the best interest of children, of the child, and also the idea that children have a right to have their say. Now, the Children and Young People Act from 2008 includes requirements for both voluntary and mandatory reporting of child abuse. This is about ensuring that children and young people are protected from significant harm, which includes child abuse, that may be occurring in their home or family environment. So the Act itself did undergo significant legislative amendments in 2024, which is where we saw that move to risk of significant harm away from just abuse and neglect. So Belle will take you through what this means a little bit more later on. Now, I guess sitting around those in the early 2000s, there was increased public debate and scrutiny about the problem of child sexual abuse in institutional context. So this led to two key things. Firstly, the development of worker screening. So here in the ACT, that's the Working with Vulnerable People scheme, which came into force in 2012. We have done a previous webinar on the WWP scheme. So if you're interested, you can go and look for that in our webinar recordings and also our fact sheets. But the second key thing that happened was the Royal Commission into Institutional Responses to Child Sexual Abuse. So that was announced in 2012 and ran all the way through till 2017, and it heard from thousands of survivors of childhood sexual abuse. And one of the key findings was that more needed to be done to prevent and protect children from abuse in institutions. And there were a huge number of recommendations made on how to improve laws, policies, and institutional practices for child abuse. So as a part of those recommendations, here in the ACT, that led to the implementation of the ACT Reportable Conduct Scheme, which is where organisations must report to the ACT Ombudsman if there is an allegation made against a staff member. And it also led to the development of what is known, I should say, as the National Principles for Child Safe Organisations. Now, these national principles are where the child safe standards have come from, and they mirrored exactly in our legislation. So the standards were legislated in 2024 as well, and they are the kind of newest piece of this protective framework. And yeah, I guess they are about the prevention element within the institutions, and they are also very, very broad, which we will get to in a minute. Probably the last piece of the puzzle is the updates that were made to the Crimes Act, which include the failure to protect and failure to report offences, which is about mandatory reporting or compulsory reporting of child sexual abuse through to the police. Again, Belle will get to this shortly. Okay, so there's quite a lot there, and unfortunately here in the ACT, that mirrors across to quite a few agencies that are involved in kind of putting those requirements into practice. So the Child Safe Standards, as many of you will know, are being led by the Children and Young People Commissioner as part of the ACT Human Rights Commission. The Working with Vulnerable People scheme is delivered by Access Canberra. The ACT Ombudsman delivers the Reportable Conduct scheme. And we're not covering those today, but you can see on our website the previous webinars and fact sheets for those two. And then what we're here talking about today is that reporting element. So ACT Children, Youth and Families are responsible for implementing the Children and Young People Act, and that includes those reporting elements around risk of significant harm. Now, as I just briefly mentioned, where there is a concern that relates to child sexual abuse, there is a bit of an overlap between the reporting requirements, and that is, I guess, jointly managed by Children, Youth and Families and ACT Police. So police become responsible where the harm is being caused by adults outside of the home or family environment, including where it might be being caused by another young person. Just a quick note to say that we're well aware that there is plenty of other legislation and regulators that exist in the child safety space. So, for example, we've got SEEKA for the education sector. We've got separate regulators for health and out-of-home care. Okay, so just to set us up for today, we are focusing on that child protection reporting element. And there is some crossover between our requirements, but also some pretty key differences. So the child safe standards apply to organisations, so they are an organisational level requirement. And the organisation is responsible for ensuring that they implement the standards. So staff and volunteers have to support that, and they will have some obligations in terms of their conduct and, you know, attending training and things like that. But the organisation is the one that is legally responsible for the implementation of the standards. Child safe standards absolutely includes reporting and responding to concerns about abuse, including those concerns that might come from the home environment. So that's where our overlap is. The child protection reporting laws around mandatory and voluntary reporting and reporting of child sexual abuse primarily sits at the individual level. So an individual is responsible for reporting where they have concerns or a reasonable belief that a child might be at risk of significant harm or sexual abuse, non-accidental physical injury in their home environment, of course. Now, whilst those obligations sit at the individual level, both for mandatory and voluntary reporting, organisations do have a kind of role to play in making sure that they've identified who might be a mandatory reporter, and they've put in place the right policies and procedures to support their organisation, their staff within their organisation to meet those legislative reporting requirements. All right, moving along. So brief recap on the standards. I'm aware that many on this call will have already attended one of our general webinars or maybe one of our previous sessions on this on regulation. But just to recap, the standards were introduced from the 1st of August 2024. So we are almost at 2 years, and they do require the organisations to implement the 10 child safe standards, which are up on your screen. So as I mentioned, the standards are aligned to the national principles, with the key difference being that here in the ACT, the standards are going to look at all forms of abuse and harm. So not just child sexual abuse, we're also looking at physical abuse, emotional, psychological, neglect, bullying, discrimination. In ACT, the standards and who have to apply them is really broad. So because it is come in under human rights legislation, it is any organisation that provides services for children or young people under the age of 18. So this is broader than many other sectors, many other states, and it's generally broader than most of our other kind of child abuse protective framework requirements. So it does mean if you have contact with children or young people or you deliver any form of services, you will be in our scheme. As I said, the standards are about that organisational practice by staff and volunteers and the things that happen within the organisation's walls. So where a child might go to school, or they might go to sport club, or they might be at afters program, it is about what happens when they are there. Now, really the standards are about changing that institutional culture, which is kind of making sure that we're shifting towards that prevention of harm And part of this is having, robust policies and procedures, safe practices for interacting and engaging with children, staff screening and training, involving children in decision making and sort of letting them participate in how to keep themselves safe, and reporting and investigating mechanisms for those concerns. Now, we always like to include this slide because it's a bit of a summary of the why behind the child safe standards. So the intent of the child safe standards is to guide organisations to be what's known as a child safe organisation. Now, this definition came from the Royal Commission, and it says that a child safe organisation does three key things. Firstly, it creates a culture and environment where children and young people's safety and well-being is at the centre of thought, values and action. So we're putting children first. Secondly, it's an organisation that places an emphasis on genuine engagement with and valuing of children and young people. And then thirdly, it's an organisation that creates conditions that reduce the likelihood of harm occurring, increase the likelihood that harm gets identified or detected, and responds appropriately when that harm or concerns get raised. So I guess for today, we are doing a bit of a zoom in on that increased likelihood of harm being detected and responding appropriately when we do detect it. All right, so that's it from me for the standards for now. I'm now going to hand over to Belle, who is going to walk through those requirements in terms of child protection reporting.
Sorry, it has also just started hailing right outside my window, so apologies if all you can hear is the sound of heavy rain and hail.
Not at all. You sound great.
Beautiful. So I think I've taken control and should be able to use the slides. That is not working. We did do a test run, I promise, and it worked perfectly.
Try again. I've just hit the box, the approve box again.
No, that's right. If you're happy to click slides, I can talk and then if need be like, and next. Beautiful. So what is child protection reporting? You'll hear some kind of shifting in language in this space for anyone who's been around or in working with children in the ACT for more than the last couple of years. In 2024, as mentioned, our legislation shifted to update our language to talk about a risk of significant harm rather than solely talking about abuse and neglect. A number of reasons for that shift in our legislation, but one of them being removing, I guess, the stigmatization and a lot of the kind of biases that come with those languages that have happened over time. There's a lot of intention that comes with those languages, where we know that significant harm experienced by children is a lot of the time not at all linked with any intention from the parents or carers involved in that child's care. So a shift from the impact and the consequences of the behaviour rather than a focus on identifying just the behaviour. So significant harm under our updated legislation identifies that it is any detrimental effect of a significant nature on the safety, welfare or well-being of the child or young person. That definition feels a little bit clear as mud, so we have an updated kind of working definition that helps people understand a little bit better kind of what does that mean. So the significance of harm lies in its potential to cause a substantial and demonstrably adverse impact on the safety, welfare or well-being of a child or young person. This significance can result from a single act, omission or circumstance, or from a combination or accumulation of these. If harm has not yet been suffered, the likelihood of harm must be considered, extending to an unborn child after birth. One of the easiest ways to kind of unpack this that we often do when we're training new staff is to consider that everyone experiences harm in their life. Everyone falls over and skins their knee. Everyone's parent might yell at them one time in their life, 5 times in a week, however much there is harm experienced by everyone who's growing up and every child and young person. The significant harm is the thing that we're involved with. No one's going to be reporting that mum yelled at a child one time after she asked them to put their shoe on 15 times in the morning before school, but they're going to be reporting if that mum or dad or adult who's providing care then assaults that young person, hits them, leaves a mark, and causes quite significant harm. So really important that we understand the significant harm is our core business. Harm is something that we all experience, but that significant harm is really what we are trying to prevent and become involved in. Next slide. So when we talk about significant harm, we do still talk about the things that are the circumstances that may cause significant harm. So again, limiting kind of what we're involved in. We're not talking about significant harm where a child is crossing the road and gets hit by a car driven by a complete stranger. That's not going to be the business of child protection in the ACT, because that is unfortunate circumstances, definitely significant harm, but it's not being caused within the family environment or by the people providing care to that child or young person. It's also not one of our harm types. So our harm types or contributors to significant harm include sexual abuse, grooming or sexual exploitation. It includes physical or emotional abuse. It includes a child or young person's basic physical, emotional, developmental or psychological needs not being met. That one was previously referred to as neglect. Again, really separating out that it's not the absence of doing something, which is often what neglect is seen as, but actually the impact, so that the young person's needs are not being met is what we're actually worried about, not that they didn't have dinner one night. It was that their need to have enough food to be able to grow strong on a regular basis is what was not met. And lastly, the child or young person being exposed to family violence. So all of those are now legislated as the contributors or circumstances that may cause significant harm and are what we're kind of looking at and talking about today. So again, we also have had some significant practice framework changes in the ACT, which are still rolling out. It says mid-2024 here, but we are still very much in early days of a 5-year implementation for what's called the Signs of Safety Practice Framework. This is now our primary approach to working with children and families. It is a collaborative, strength-based and solution-focused approach to child protection work. It allows us to strengthen our risk assessment and maximise family participation to actively contribute to solutions for keeping children and young people safe. I won't go into too much about signs of safety. It's just kind of letting you know that it is a shift in our practice framework. It's a change in the language that you'll be hearing. There's a shift to looking at what's working well in a child's life, their strengths, understanding who is worried and why, what are the worries, what are the dangers and concerns for this young person or young people, and identifying what needs to be done to build on the strengths, increase safety, or reduce the level of worry or risk to the child or young person. So that's the kind of shift in language that you'll be hearing from us and our practitioners. CYF will continue to provide some kind of briefings and resources. Please reach out if you're interested in any of those to help our community partners understand signs of safety and just kind of make sure that you're understanding that language that is coming out and ideally kind of have similar language across organisations. So types of reporting, when we talk about types of reporting, I'm going to talk a little bit about mandatory and voluntary reporting, but we also have sexual abuse under the failure to report and failure to act legislation changes that we talked about a little bit earlier. So from 1st of September in 2019, there were new child sexual abuse reporting laws that came into effect. These are now laws that specifically manage failing to report in the context specifically only to sexual abuse. So if it becomes known that a mandatory reporter failed to report, there are penalties. Any adult must report to the police if they believe reasonably that a sexual offence has been committed against a child or young person. So what do you need to report if that applies to you? You need to report any information about a sexual offence committed against anyone who was under the age of 18 at the time the offence was committed. So that means if that person is now 19 and they've disclosed something that happened 2 years ago, that's still covered under that reporting. You need to report that that offence has occurred or potentially has occurred to police and or to children, youth and families. If it is not our core business, we automatically notify police anyway. But if it's, again, a sexual offence committed by not a family member, not a parent, not a guardian, not a step parent, then that's not going to fall in our remit and we would be passing on to police. But if it does fall in that family environment, reporting it to us, we will still pass it on to police because there's usually a dual assessment or investigation that occurs. I won't go into them, but some of the most common sexual offences in the ACT are listed there. Again, we're being clear that this is not just the most serious and violent sexual offences. This covers, like I said, those grooming, those sexual exploitation, those child trafficking offences are also covered under that failure to report. So if you are concerned or have information or disclosures in that space, please do contact police and or CYF. So some exceptions to reporting under that failure to report obligation specific to sexual abuse. You do not need to report in these circumstances. So if you obtained the information after the victim became an adult and you believe he or she does not want a police officer to be told. So again, if you have your 19-year-old who is disclosing that when they were 17, something has occurred and they are very adamant to you that they do not want to make a statement, they will not be talking to police, you then do not have to report. You may still choose to report because you want to share that risk and let somebody else kind of also make that same decision, but your mandatory reporting then doesn't apply if they've been really clear that they don't want to action that. You also don't need to report if you believe a police officer already has the information. So if police have contacted you or your organisation wanting information and have disclosed something that has potentially occurred, you then don't need to go and re-report to police to say, hey, I know you just told me this thing. I'm also going to tell you this other thing that's occurred. So if police already told you, you don't need to go and tell them again. If you believe that giving the information to a police officer would endanger somebody's safety other than the safety of an alleged abuser or person causing harm. If you are aware that legal privilege applies, noting that no privilege applies for religious confessions. So again, if it's a lawyer and their client, then they're going to have legal privilege, but outside of that space, you should be providing that information. If you are a mandated reporter and you have already reported the information to children, youth and families, so if you've already contacted CYF, you then don't also need to report to the police. Because like I said, we will always pass on any reports around sexual abuse to police so that there's any dual investigations that need to occur, they can occur. You also are accepted if you know that the information is generally available in the public domain. So this one, again, if you are watching a Netflix documentary, if you are watching the news and there is information about a sexual offence that has occurred, you then don't need to go and tell someone because that information is publicly available. So someone is already aware of that and actioning that however they need to. And lastly, you have another reasonable excuse. So again, if there is a reasonable excuse that you can provide should that issue ever come up, but again, it's not usually common that someone would be underreporting. That's all for that one. So just to kind of cover a little bit more around what the difference is between our mandatory and voluntary reporting in the ACT. So in the ACT, mandatory reporting is the legal requirement under the Act, so the Children and Young People Act, for certain professionals to provide information to CYF if through the course of your work you believe on reasonable grounds that a child is being or has been sexually abused or is experiencing or has experienced non-accidental physical injury, also known as physical abuse. You are mandated when the reasons of the belief arise from information obtained during the course of or because of your work, whether paid or unpaid. That last little bit is really clarifying that if you are out to dinner with friends and your children are playing and another child comes up to you and discloses potential physical or sexual abuse, you're not a mandatory reporter because you're not at work. You are out with your family having dinner when you come across that information. You are very likely to still report that information because you would be concerned for that young person or that child. But your mandatory reporting obligations are only if that disclosure or that information comes to you when you are at work or in the line of you doing your work. We have sometimes been asked around, how does that count if you work during the week, Monday to Friday, but then on a weekend you're at a barbecue volunteering to do with your organisation outside of normal work hours? If you are still volunteering in line with your work, you're still a mandatory reporter during that period because you're still connected with your work duties, voluntarily extra work duties. Hopefully that makes sense. Voluntary reporting is when a person believes or suspects a child or young person has experienced, is experiencing, or is at risk of significant harm. So voluntary reporting also includes reports of unborn children who a person believes or suspects may be at risk after birth. This is called prenatal reporting. So our mandatory reporting is really clearly only about the physical, non-accidental injuries or physical abuse or sexual abuse. Voluntary reporting applies to all of those contributing circumstances for significant harm. So those needs not being met, emotional abuse, family violence, and physical and sexual abuse just under the mandatory reporting. So clarifying again, Mandatory reporters must and voluntary reporters may report when they have genuine concerns about the safety or well-being of a child or young person. It is an offence for a reporter to make false or misleading allegations, but you're also protected when you make reports with genuine information. So mandatory reporters, I'm not going to read out everyone that's on the list, but effectively, if anyone is working with children, you are more than likely a mandated reporter. So all the obvious ones, your teachers, your doctors, your dentists, but our last little clause there is section T, which says a person who in the course of the person's employment has contact with or provides services to children, young people and their family and is prescribed by regulation. So if you are someone who works with children and young people in a paid role, you are more than likely a mandatory reporter, even if your name isn't on the magical list. The exclusions to that, the people that kind of fall in the loophole, is when we might have a student placement who is at your work in a voluntary capacity, unpaid internships, grey area. But I can clarify if anybody has a specific question about that, and volunteer. So if you have volunteer who are helping out at fundraising events, community days, they are likely not mandated reporters, but they are still going to be voluntary reporters. Anyone who is employed, paid employment, is a mandatory reporter if you're having contact with children and young people, is the easiest way to think about it. So some people are worried that if they provide information and report their concerns, that they might then get in trouble. The family might find out. Somebody might try to then sue them for defamation if those concerns don't turn out to be anything. Ideally, that is not the case because you are provided protection under the Children and Young People Act. So you have protection of your identity. So anytime you make a report, voluntary or mandated report, any detail that identifies you as a reporter and the contents of your report are exempt from the release under the Freedom of Information Act. So you're protected. It will not be disclosed who reported concerns to us. This one is really important because sometimes we will have families who then approach their teacher at school, their family friend, their neighbour, and say, I know that you reported, CYF told me that you reported. You can be rest assured that CYF did not tell them, but it may be a strategy for them to try and work out who that reporter was. So being really clear that that information is never disclosed by CYF. And if it is disclosed, then it is an offence that CYF then investigate and respond to if there is any form of disclosure, because that protection for reporters is really important. Reporters also have protection from prosecution. So again, legislation provides that if the information is provided in good faith, the reporter cannot be liable for any civil, criminal or administrative proceedings. However, it is an offence to knowingly provide false or misleading information. So if you are genuinely reporting concerns for a child or young person, you are then protected that that is not going to be used against you. There's no proceedings that can be commenced against you in that space. So this one's kind of skipping back to our mandatory reporting obligations. So the exemptions for mandatory reporting. So similar to how we have the exemptions for reporting of sexual abuse, we also have exemptions for mandatory reporting. So remembering that mandatory reporting applies to physical and sexual abuse. Our failure to report criminal legislation change was only about sexual abuse. So exceptions for mandatory reporters, you do not need to report if you feel that somebody else has made a report to the Director General, so CYF, about the same child or young person in relation to the same abuse or non-accidental physical injury, and the other person has reported the same reasons for their belief as this person has for their belief. Legislation talk, what that actually means is if me and my co-worker both spoke to a young person who disclosed something that was occurring at home, that they have felt unsafe, we're really concerned about what's happening for them, we don't then both need to make a report. If I talk to my colleague Amna and she says, I'm going to make the report about the concerns that that child or young person disclosed to us about what was happening at home, are you happy for me to make the report? Amna makes a report, I then don't also need to make one. We sometimes get asked the question of, but how do we know if that other person has made a report, and therefore am I going to get in trouble if they said they were going to make a report but they didn't make the report? Again, on reasonable grounds. If I've spoken to my colleague Amna, she said she was going to make the report. We were both really clear that she was going to make the report, and then she forgot and never made the report. I'm then not going to be liable as a mandated reporter because on reasonable grounds, I believed that somebody else was going to make the report and that we both agreed they were going to make the report. We don't both need to double up. Section 356 also says that if a person does not need to report if that child or young person has experienced non-accidental physical injury caused by another child or young person. So if it's another child or young person who has caused the harm, then you're not a mandated reporter in that respect, because the harm's not being caused by an adult. So if there's something that's happening at school, in a sporting activity, in after school care, and it's a child or young person that has harmed another child or young person, then you're not required to report that physical or sexual abuse to CYF. And then lastly, if the person with parental and if that person or with parental responsibility for the injured person is willing and able to protect the injured person from further injury. So if we have a young person who has, let's say, significantly physically assaulted another young person during after school care, mum has said, oh my God, I'm horrified, I'm going to intervene. Mum of the child who's caused harm is horrified, they're going to intervene, they're going to seek support for both children or young people involved. There's no mandated report obligation. If the young person who has been injured, mum collects them and says, oh, they do appear to have a concussion and a head injury, but I'm not going to take them to a doctor. I'm sure they'll just sleep it off and be fine. You might then say, well, actually, I'm really concerned that that young person has a concussion and they need medical treatment. So I'm going to report my concerns that our parent in this case is not meeting the needs of that young person because I'm concerned that there could be significant consequences for an untreated concussion. Hopefully that makes sense. So when you're reporting significant harm or concerns of significant harm, tell us as much information as you can about the child or young person. So we want to know their name, their age, their address. If you give us really detailed disclosures from a child or young person, but we don't have their name, age, or address and no way to identify them, that report will just sit in an unknown in our system. It's recorded, but we cannot do anything. We cannot respond because we can't identify that young person. The parents, caregivers, and others living in the home. We want to know who it is you're talking about. If you're talking about mum's boyfriend or the stepdad of the children, it could have been 6 years since our last contact with the family and we don't know who the stepdad is. So really important that we know who it is that you're talking about. It's really important you include the reason that you suspect risk of significant harm. So we don't want to know that the child presented with a broken arm and therefore mandatory report. Children break their arms, accidents happen. We want to know that you're concerned that the child refused to make eye contact when you asked them what happened to their arm and that mum was really angry towards them at pickup that day. And the child has had multiple other injuries and we're really concerned that this is a pattern, that this is a non-accidental injury, not just a child has an injury, therefore must report. We also want to hear any support services you know about for the child or young person and their family, any relevant circumstances, is there substance misuse, mental health issues, housing pressures, finances, what else is kind of happening for the family that could be contributing to their situation. Any contact details of the family if you have them. Another important step, if we have all the information but no way to contact the family, then the likelihood if it meets our threshold where we are concerned enough to be involved is that we can then turn up to somebody's doorstep without warning. We would always prefer to be able to call a family, talk to them on the phone, let them know that we want to come and talk to them about some concerns rather than someone turning up on your doorstep out of the blue. But if we have no way to contact a family ahead of time other than an address, then that makes it really hard for us to do that. What not to report. So children and youth and families are unlikely to investigate one-off sexualized child play, such as exploration with a similar age child. So if you have children that are at childcare and they're running around with their shirts off, we're probably not going to be looking at that as risk of significant harm. So you don't need to be reporting it unless you have a concern that there is sexual abuse occurring to one of those children. Teenagers engaging in consensual sexual activity with each other. So 2 17-year-olds in a relationship having sex, you don't need to report that to us just because they're under the age of 18 because they are not committing any form of sexual offence and there's no element of sexual abuse. Different story if you are concerned around the dynamics in that relationship. But again, if it is young person to young person, it's then not going to fall under that mandatory reporting obligation. So then it might be around seeking support for the family and the well-being for the family rather than it being around our risk of significant harm. A child who is self-harming when there are parents willing and able to protect them. So again, if we have our 15-year-old who is experiencing a mental health decline and is engaged in some self-harming behaviours, mum or dad is aware, they are taking them to access services and support, we don't need to know about it. That's again, that space of harm versus significant harm. That young person's experiencing poor mental health, engaging in self-harming, and their parents are supporting them in the best way that they can. different situation if it's our 15-year-old who's engaging in self-harm, articulating suicidal ideation, and their parent or carer is refusing to acknowledge their concerns, dismissive, providing them access to further tools to harm themselves, then we would be really concerned and we would be reporting to CYF. Children who have been fighting in the playground, that one feels pretty obvious, that if some kids in the playground are fighting about somebody stealing somebody else's toy, somebody stealing somebody else's boyfriend, girlfriend, partners, then that's not our core business. That's managed within the school, within the families. It's not children, youth and families business. Children who are upset because their parents are getting divorced. So again, this one really sits in that threshold of our work and that space of harm. So any child whose parents are going through a divorce is going to be experiencing harm. They're going to be distressed. They're going to be upset. But that's not a reason to report to CYF. It's not mandatory reporting. It's not voluntary reporting. That's just unfortunate circumstances and harm being experienced by that child or young person. If those parents are now weaponizing the children against each other, withholding the children, coercing the children to say certain things, make false disclosures, and creating significant harm for the children, then you might be reporting that to us, but the parents also might be engaged in family law court proceedings and attempting to resolve those issues. So then you're going to try to understand a little bit more to determine whether or not that risk of significant harm is there. And lastly, a child who's given the same lunch every day at school. So you might say, I am very displeased that that child or young person is having pre-packaged processed food, and that's not very good for them. I think they should be having homegrown, homemade foods in beautifully assembled bento boxes with hand-cut sandwiches with their crust removed, only healthy, not risk of significant harm, not something that you need to be reporting to us. That's just effectively personal opinion and bias rather than significant harm or our core business. I think that covers those. So this and the next couple of slides are just some tools and templates that we use and provide to staff and community around reporting significant harm. So understanding, okay, these are all things I need to report, but how do I make an effective report? How do I make a report that gives you everything that you need? And what type of questions should I be answering? So there's this one, and then if you click through, I'll talk a little bit more about the next one. Basically, strength-based reporting is our approach to this. So we have updated our online reporting form, which I will talk a little bit more about, which will now also prompt community to answer these questions when making a report. Because like we said, not very helpful if you have a child or young person attended my service today, had a broken arm. Mum doesn't really talk to me at pickup, really concerned that there might be non-accidental injury. Not a helpful report, very likely that that is not going to progress or proceed in our organisation past a threshold assessment for risk of significant harm. However, if that report also talks about what's been happening for mum, how long that relationship has been occurring, that this isn't the first injury, what the child has said about that injury, what support you've tried to offer the family and hasn't worked, all of that extra information is going to help us to understand, okay, this is what's actually happening for the family. I really understand why you're worried, versus just, it sounds a little bit judgmental if you were saying, oh, mum didn't really want to talk to me and the child had a broken arm. That isn't in itself enough for us to really understand what's happening for the family. So these prompts are really helpful. When we do site visits with our community partners, we pretty much recommend that they print off this slide and the next slide and use them as your little self-prompt guide when you're making a report around how do I think about making a report, what's important to include, because usually it's really clear that I want to include my little piece of the disclosure or my piece about the worry. But then asking yourself these questions will really help you to kind of slow down that thinking and articulate those worries really well so that we have as much information as we can and can understand what you're worried about and why you're worried and what you think needs to happen as well. Beautiful. Next slide. So how to report significant harm. So if significant harm or the person causing the harm is within the child's family environment, so if it's coming from mum, from dad, if it's from the step parent, if it's from mum or dad's boyfriend or girlfriend or partners, if it is happening in the home environment, in the family environment, then you're reporting it to CYF. So the first option there is a little clickable link that is the reporting of significant harm online. You can also call us, Children, Youth and Families. That phone number works for both mandated and voluntary reporters. It's the same beautiful team of intake staff who are always happy to answer any questions as well. So Two ways: online form or phone call. If you're not sure if it should be something that you should report, you need to report. Is this mandated? Is this not mandated? Is this harm? Is this significant harm? You're always welcome to give us a call and chat through those concerns. Or if you think it's not significant harm, but you don't know how to support the family, then giving us a call to chat it through. If that harm is being caused by somebody outside the family environment, so like we've said, if that person is a stranger on the street, person known to the child or young person, but not part of their family, then it's contacting police in that space. Again, if you're ever unsure, police and children, youth and family staff are always happy to answer those questions through phone calls to help you understand which pathway you should be taking. So what happens to the information that I provide is a very condensed version of our kind of workflow and internal processes. But if you are interested in hearing a little bit more about kind of all of the significant harm NCOF role and kind of what we do, there's a little link to some further training that we provide in this space. But anytime that we receive information, so anytime you're contacting us to make a report, we are legally required to undertake an assessment to determine if that child or young person may be at risk of significant harm. So that assessment is determined by our staff as to kind of what level of assessment is needed. It's not necessarily the case that that first phone call you make to us will then lead to us going out and visiting the family face-to-face the next day. We undertake significant amounts of information gathering in the office and prior to us doing that face-to-face engagement, because we're also balancing those families' right to privacy and right to not have us in their lives if we don't need to be there. So we want to really understand as much as we can. So the three kind of options when you make a report to COAF are that a more detailed investigation should happen and that information is recorded. So we say, yep, that does sound really concerning. We think we need to look into that more. Option two is a support intervention is more appropriate, but the information will still be recorded. So you might say, I'm really concerned because mum's been drinking and she has a 15-year-old at home. And we might say that is really concerning, but we're not concerned that the 16-year-old's going to starve because mum is drinking. Limited information. So we might have a conversation with mum, refer her to some support services. Information still recorded, but it's not going to progress any further. Or we might determine that no action is needed and the information is still recorded in our system. So at all points, the information you provide is still recorded on our system and attached to that child or young person. It's just the next step that is then determined by our staff. So a little pyramid down the bottom here kind of talks through the level of information gathering and level of intervention across COAF. So top of our little pyramid is our intake CCR risk assessment. That's generally pre-face-to-face. So all the information gathering that we do, some additional referrals that we might make, we might link them in with one of our support response teams, we might link them in with the community service support, or we might just determine that there's no risk of significant harm at all and the concerns were about the children having nuggets for dinner 5 nights a week during school holidays. And we would say that is not risk of significant harm, that is school holiday life. So we're kind of screening things in or out at that intake stage. Our appraisal risk assessment then is working with that family more intensively, where we're concerned that there is a risk of significant harm and that child or young person may be in need of care and protection. So again, under legislated thresholds, we're looking at kind of what support and safety can be put into place to reduce that risk of significant harm and determine what support the family might need. Ongoing risk assessment occurs if that child or young person has ongoing risk of significant harm. That can look like the children or young person coming into out-of-home care. That can look like further assessments, further ongoing or medium and long-term interventions. So again, our little pyramid shows the amount of information and the amount of intervention that we provide increases down that pyramid, but that's not to say we can't kind of refer out and step those families back up into community supports where we can. So what if you have concerns about a family, but you're unsure or you think that they don't warrant reporting to COAF? So if you have those concerns, but you're not really feeling like it's risk of significant harm, maybe it is your mum who's really struggling with her mental health. She's got 3 young children and is just feeling really overwhelmed. She's doing her best and you think she just needs some support. If you sit in that space, you might speak with the parents. So speaking with the parents about your concerns might be the first step. Working with the parents to resolve any issues, either by being actively involved, connecting them with other services, or by letting them know that you are there if they want some help. Speaking to a child or young person, if your role is engaging with children and young people. If it's not, then that's not in your remit. But if you know the child, having a gentle conversation with them, letting them know that you're worried that there may be something wrong, by simply offering to listen, you can help the child open up about an issue. And additionally, consider available support services. So helping in other ways. So connecting them with free support services. This might help if you see issues, but think a significant harm report is not needed. So a mum struggling with her mental health, you might be linking her in with First Canberra or the child and family centres. So services that can provide that early intervention or kind of medium intensity interventions without it needing to come to CYF, because you're kind of looking at preventing that significant harm occurring, rather than saying, oh, that mum is not coping, let me wait 6 to 12 months until she's really not coping. And then we're seeing some impact on those children. So really important that we link families in with those support services. Caveat though, if you believe physical or sexual abuse is occurring, the information needs to be provided and you shouldn't take those actions instead. You might still provide support to the family, but you really need to be reporting in the first instance for physical or sexual abuse. And I'll hand back to Gemma.
All right. Thank you, Belle. That was very comprehensive. Hopefully that's given all of our participants online a really clear overview of those reporting requirements. I am conscious of time because we do want to make sure that we have some time for a Q&A, but our next little section is just briefly going to look at where the Child Safe Standards can support you as an organisation to meet those requirements in terms of reporting. So the child protection reporting is primarily about identifying and reporting harm that might be happening in a child's home environment. But a big part of this is simply just the ability of staff and volunteers in your organisation to actually recognise that harm and to know that they need to do something about it. So that's kind of the intersection for the Child Safe Standards. And I guess whilst we say the Child Safe Standards are interrelated and implementing all 10 of them help you and your staff to identify harm, both within the home environment and within the organisational setting. We're going to spotlight a few of the standards today. So today we're going to look at Standard 3, Standard 6 and Standard 7. But I guess also just want to call out that there is a really strong link here between child protection reporting and the Child Safe Standard number 10, which is policies and procedures. So I know many of you on this call will have, that you're responding to child abuse and harm procedure, things like that. And you should absolutely make sure under the Child Safe Standards that you have those documented procedures for reporting, including identifying who might be a mandatory reporter, the process for identifying and reporting risk of significant harm, and actually just how you support your staff to execute those reporting functions if they need to. All right, but Standard 3. Standard 3 is about families and communities and making sure that they're informed and involved in promoting child safety and wellbeing. So organisations, what can you do? I guess firstly, yes, make sure that your families are aware of your organisational child safe policies and procedures, including, your requirement to report if they've got concerns. Encourage your staff to have regular and open conversations with families about your practices and the role of the family in keeping children and young people safe. As kind of touched on through a lot of Belle's examples, it's also really important that your staff have an awareness and understanding of different cultures, and they have an awareness of their, unconscious bias when they're thinking about identifying risk of significant harm, because all families will do things different ways. And what we don't want is for staff to kind of slip into, this bias-based reporting. And I guess, again, just as Belle mentioned, one of the key things under the Child Safe Standards is making sure that families get support. And so as an organisation, we want to help them by building those trusted and supportive networks. So, your staff, your organisation, but you may also have a role in being able to connect them out to further sort of community support groups, local elders, those sort of things. All right. Child Safe Standard number 6. So this is our one about reporting. So children, families and staff must know how to speak up if they have concerns about things that people in the service are doing or about significant harm on a child's life elsewhere. So make sure you've got visible information about reporting concerns. You've got staff who know how to listen respectfully, and they also know how to identify concerns even when a child might not have said anything. I guess you want to make sure that your staff and leaders know what to do, so they're aware of mandatory reporting, and you're either supporting them directly to execute those reporting functions, so helping them sit down and fill out the online form, or you're at least making sure that they are really clear about how to do that, when to do that, and they're being given the time. So if you're a childcare centre and a staff member has a concern, you're making sure that they have the opportunity to be pulled off the floor to make that report if they need to. Child Safe Standard number 7 is around people working with children and young people to be suitable and supported. So education is a big part of this. So making sure that staff are provided with information about child safety, they get the training, they are able to recognise the signs of abuse and significant harm in children. Now, on that note, there is mandatory reporting sort of training. I think it's called Training to Respond to Child Abuse and Neglect, but it will be updated, no doubt, to call Training to Respond to Significant Harm shortly, but that training is free. I believe there is online and in-person options through Children, Youth and Families, and anyone in your organisation who is a mandatory reporter should absolutely be supported to do that. All right, so we are going to have a fact sheet published that will have those sort of standards laid out and some of the actions. So you'll be able to get a copy of that following today's webinar. But I guess, the child safe standards are flexible, they're quite broad, they're non-prescriptive, and we know that organisations are often keen to understand exactly how and what they should do to put those standards into action. So there isn't just one way, but here's some examples of some practical things that you can do to implement Childs 3, 6 and 7 and 10 and ensure that you're meeting those child protection reporting requirements as well. So firstly, you absolutely should be providing copies of child safety information to family, and you're making sure that information about how to raise a concern and make a report is given to all of your staff. You want to identify positions that might be mandated reporters and make sure that the staff themselves are aware of that. So they know they're in a mandatory reporting role and they know what that means. You should communicate the expectations to your staff on reporting. So encouraging that openness, encouraging staff to feel safe to speak up if they have concerns, regardless of whether that concern is, child's home environment or something happening in the service. As Belle said, if you're unsure, you can absolutely contact CYF for advice via the phone. They have a good call line. They can answer your questions. You should make sure that you've got written procedures for reporting risk of significant harm, as well as reporting harm that might be occurring in your organisation. And whilst CYF will always keep records about reporting that your organisation do, we recommend that you keep records of any complaint, allegations, suspicions and disclosures, including, mandatory reporting. So if you do have concerns about, privacy or protection, that's okay, but you should still make a note that something was reported, because that can help you later down the track. It can help CYF if you've got one concern now and then in 6 months you feel like something's escalated and you need to kind of report in further information. All right. There are heaps of resources out there for both of these elements. So ACT, Children, Youth and Families have the training, as I mentioned, and they also have a good guideline called Keeping Children and Young People Safe that has all of this information and more in it. It is a PDF doc. You can get that printed out, share it around to your staff. From the Child Safe Standard size, we have our self-assessment, we have a practical guide, and we will have a fact sheet that gets published after today. Okay, we've got 1 minute left for our questions. So conscious, I know some people may need to leave, but we did have 2 questions submitted ahead of time. So the first one was, does the scheme require staff and sporting organisations to report? So are staff and sporting organisations required to do mandatory reporting? So Belle.
Yep, in shortest form possible given our time constraints. Yes, so again, we already spoke about it a little bit previously, but those mandated reporters are going to be anybody who has that contact with children and young people. any of your staff who are employed under a sporting organisation, if they hold a WWVB card, they're prescribed by regulation, therefore they're going to be mandated reporters. It's realistically only going to be your volunteers who are coming and assisting who aren't employed by the organisation that are therefore not going to fall under that mandatory reporting obligation. Again, in the ACT, we don't have too much of an issue with underreporting. People generally, if they're concerned and they have contact with children or young people, will make those reports.
Great. Second question was, what has changed with the new online form for reporting risk of significant harm?
This one I also already spoke about because I preemptively knew that question was coming. But effectively, our reporting form has changed. It no longer is the kind of one little box of dump in whatever you need and thanks, see you later, I'm done my report. It is now a much longer form because we need that information from you to really understand what's happening for the child, what's happening for their family, and what we can do to assist them, or what you feel we can do to assist them, how worried you are. It's a much more strength-based form, but it's also a much more comprehensive understanding of what's happening for the family. Those questions and that approach are the same if you call or if you make that online report, but the difference being when you call, you can also seek that additional advice if you're not sure where that sits for a family. I'm happy to walk through the form or provide some education if there's areas that need or want some support in kind of understanding the new form and how they can do that. Please feel free to reach out to our team and we can provide some additional resources or some education sessions on the new form if somebody would like some extra training in that for their staff.
Fantastic, thank you, Belle. And I think just quickly, key point to note on the new form is that the location of the form hasn't changed. So if your policies and procedures or anything has a link to the form, that link should still be live and work. So don't stress about that. It has gone past 2 o'clock, which I apologise for, because normally we do like to try and have questions from the floor. If you would like to stay and ask a question, you're welcome to. I'm happy to stay online. Otherwise, please post any questions that you may have in the chat, and myself and Belle can make sure that we get back to you with a response to those questions or give you a call back. So I'll just give a minute in case anyone wants to throw their hand up or type something in. Otherwise, we will wrap up for today. Nothing too forthcoming. So yes, absolutely. Thank you very much for your time today, everybody. I hope it has been useful. Up on the screen at the moment is our satisfaction survey, and I would love your feedback on today's webinar because through feedback, that's how we know what's useful and how we improve our child safe standards education going forward. We also have a year 2 survey, which is currently live. You will get a link to this in the follow-up email, which will come out in the next day or so. And we will include the resources that we discussed today and links to register for upcoming training that is happening in the month of July. So in terms of training, we do have our final webinar in the Child Safe Standards and Regulations series on the 27th, Monday, the 27th of July, that is looking at ACT and New South Wales Child Safe Standards. So delivered in partnership with the New South Wales Office of the Children Guardian. That one's really aimed at organisations who are operating across jurisdictions. We also have our second community of practice happening. So there's 2 dates for that, 21st of July and 23rd of July. The topic for that one is on child safe recruitment. Okay, I've just seen someone chuck a question into the chat. Apologies, I missed this in the Q&A part. I can't pull it up right now. Let's have a look. Wondering if there are specific questions made depending on culture beliefs. For example, if a child's needs not being met and the parent doesn't take them to the doctor if they're injured, but that's a, somebody who's got a different perspective in terms of medicine and the use of medicine, summarising, what would be our response there?
Yeah, so hopefully I did answer that a little bit, but again, it's really based on that threshold of significant harm. So a child being tired whilst they're fasting, that's going to be harm, but it's harm experienced in the context of what they feel is appropriate. That child's not distressed, that child doesn't have an ongoing failure to thrive because they're doing that. It's part of that family's cultural beliefs and their normal procedure. So if that teacher was concerned and was making a report, it's very likely that we would be recommending no further action and that wouldn't be screened in for risk of significant harm. But ideally, we're educating our teachers to be able to kind of distinguish that difference and say, well, I've spoken to mum and she explained that it's Ramadan and that's why they're fasting, and this isn't their typical behaviour, so I'm not concerned. therefore I'm not progressing it further. Same with the medicine. If somebody is a diabetic and their parents decide that they don't want to give them insulin, we might be a little bit more concerned that that's going to fall under our thresholds. But if it's a parent who has decided that they're not going to give their child Panadol for the slightest headache, then that's a decision in that space if they would prefer remedial massage versus physio, those kind of differences in approach for those things, as long as there's not a significant harm, impact, or consequence for that child or young person.
Fantastic, thank you. All right, thank you everyone. As I said, if you did have a question that you didn't have the opportunity to ask today, please feel free to contact us. Our email addresses, there's two, depending on who you want to contact, but you can send anything through to my team at actchildsafe@act.gov.au, and we will make sure that it gets answered. As I said, keep your eye out on an email coming to your inbox in the next day or so with all of the information from today. If there's anything else that we can do to help you with the child safe standards or child protection reporting, please do reach out to us. Thank you very much all, and we hope to see you on one of our future webinars.